Welcome to This Explainer. Have you ever actually stopped to wonder how our global society, with all of its competing cultures, wildly different interests, and let's face it, occasional conflicts, how it all actually manages to operate? It's like a massive, incredibly complex puzzle, and today we are going to absolutely demystify it by taking a close look at the world's rulebook.
That brings us to this absolutely wild core paradox of our global system. Think about it. Without a world police, how do countries avoid descending into utter chaos? In our own cities, if someone breaks the law, the police show up, right? But globally, there's no supreme world government sitting up there with a giant gavel, no top-down enforcer. So the secret sauce here relies entirely on consent, mutual cooperation, and a shared set of rules. It's fascinating.
Okay, let's dive into this. Here's our roadmap for the explainer. First, defining the world's rulebook. Second, treaties. Agreements must be kept. Third, customary law and practice. Fourth, general principles of law. And finally, courts, scholars, and resolutions.
All right, moving right along to Section 1, defining the world's rulebook.
You see, our understanding of these global rules has completely evolved over the last century. Back in 1905, this prominent jurist named Lasse Oppenheim had a very, very rigid view of things. He basically saw international law as completely static, arguing that countries or states were the absolute only subjects that mattered. But fast forward to the modern definition by Stark, and it's a whole different ballgame. It's a living, dynamic system. Today, international law doesn't just govern countries, it governs international organizations and even individuals, all striving for peace and justice.
So you might be wondering, where is this rulebook actually written down? Is there a physical book? Well, you'll find the official table of contents, so to speak, in Article 38, Paragraph 1 of the Statute of the International Court of Justice. This master list dictates the exact sources judges use to solve disputes. We're talking treaties, customs, general principles, and the subsidiary means, which are judicial decisions and the writings of jurists.
Which leads us nicely into Section 2, treaties. Agreements must be kept.
Right at the heart of treaty law is this foundational Latin principle, pacta sunt servanda. It sounds fancy, but it literally just means agreements must be kept. Think of it like two friends making a simple deal, right? Like, hey, I'll lend you my science notes if you help me with math. Once you both agree to that, you're absolutely expected to follow through. Well, a treaty works exactly the same way between countries. Once a state voluntarily enters into a written agreement, like, say, the UN Charter or the Paris Climate Agreement, it is legally bound to follow it. No backing out.
Let's actually see this in action with a really high-stakes dispute, the North Sea continental shelf cases. So picture this. Germany, Denmark, and the Netherlands were fighting over how to carve up the highly lucrative, extremely resource-rich ocean floor right off their coasts. Denmark and the Netherlands, they wanted to use something called the equidistance principle, which is basically just drawing perfectly equal boundary lines. Germany, on the other hand, argued this would unfairly shortchange them.
Now, Denmark and the Netherlands argued that this equidistance rule was just standard international law. Everyone does it. But Germany pushed back hard. And this begs a really crucial question. Is a country bound by a rule if they never actually signed a treaty accepting it?
Well, the International Court of Justice, the ICJ, delivered a resounding answer. They ruled that treaty rules bind only consenting states. Since Germany had never signed an agreement accepting that specific boundary rule, there was no way they were bound by it. And honestly, this brilliantly illustrates the supreme importance of state consent in the modern world. You literally cannot force a country to follow a treaty they didn't sign unless, and this is a big unless, that rule has become a universal custom.
And that brings us to Section 3, customary law and practice. So what happens when there isn't a written treaty? To turn a simple tradition into a binding international law, you need two essential ingredients. First up is state practice, which just means countries must actually do the thing repeatedly over time, repeated conduct. Second is opinio juris. It's a fancy Latin term, but it basically just means countries must genuinely believe they are required by law to do it. For example, respecting diplomatic envoys and not attacking messengers. That became customary law centuries before anyone ever bothered to write it down in a formal treaty.
But proving a custom actually exists? That can be incredibly dramatic. Just look at the asylum case. Imagine this. A political rebel is on the run in Peru, desperately seeking safety inside the Colombian embassy right there in Lima. Colombia claimed they had a unilateral right to grant him asylum, arguing that this was a recognized, unwritten custom totally unique to Latin America.
Peru, as you might guess, completely rejected this.
The case went all the way to the ICJ, and Colombia lost. Why? Well, because the court sets a very, very strict standard. They ruled that Colombia failed to prove a constant and uniform custom. It turns out the practice regarding asylum in Latin America was actually quite inconsistent. The takeaway here is that for a custom to have the actual force of law, the practice has to be flawlessly consistent and universally accepted by the states involved. No exceptions.
Let's move on to Section 4, General Principles of Law. Okay, so what happens if a judge looks for a treaty, finds absolutely nothing, looks for a custom, and still finds nothing? Well, they turn to general principles of law. These are broad moral compasses recognized by almost all civilized nations. We're talking about fundamental, universal concepts: good faith, equity, justice, res judicata, which is just a legal way of saying a final judgment is final, and crucially, the idea that you are absolutely responsible for your wrongful acts. These principles basically step in to fill the gaps so that justice can still be served.
The power of these general principles is crystal clear in the Chorzów factory case. The backstory here is that after World War I, Poland essentially seized a factory in the town of Chorzów, but this factory rightfully belonged to a German company. Naturally, Germany demanded compensation, pointing out that this seizure directly violated international obligations.
In response, the court delivered a massive, landmark ruling based on a general principle. They stated, any breach of an international obligation involves a duty to make reparation. It cemented this universally recognized, almost common sense idea that if you break a rule and cause harm, you don't just get to walk away. You have to pay for it. You have to make it right.
Finally, we arrive at Section 5, Courts, Scholars, and Resolutions.
Now, judicial decisions play a massive role in clarifying the rules, though sadly, often in the wake of tragedy. Take the Corfu Channel case. British warships were passing through waters near Albania when they suddenly struck hidden naval mines. Ships were completely destroyed, and dozens of sailors tragically lost their lives. The UK accused Albania of knowing the mines were there and deliberately staying silent about it.
Albania completely denied laying the mines, but the ICJ held them responsible anyway. The court used circumstantial evidence to determine that Albania absolutely must have known the mines were there. In doing so, they established a vital rule. A state is obligated not to knowingly allow its territory to be used for acts contrary to the rights of other states. The court's decision took a broad principle and really gave it teeth. Alongside the courts, we also have subsidiary sources. The writings of highly qualified scholars, like the legendary Hugo Grotius, who essentially mapped out the laws of war and peace centuries ago. These heavily influenced judges. And today, while resolutions from the UN General Assembly might not be strict binding laws like a treaty, make no mistake, they carry immense political weight and actively shape how global law develops over time.
To tie this whole shebang together, the world's rulebook isn't just one single document. It's a dynamic, interlocking system. You have your primary sources, treaties, customs, and principles, which create the actual binding rules. And supporting them are the subsidiary sources, court decisions, and scholars that help interpret and clarify those rules whenever conflicts arise. Together, they provide the entire framework necessary for maintaining order on a planet with no single ruler.
As we wrap up this explainer, I want to leave you with a pretty provocative thought to ponder. We've established that this entire magnificent system is built on states voluntarily agreeing to play by the rules, right? So if international law relies entirely on consent and shared custom, what actually happens when powerful nations simply decide to withdraw their cooperation? It's a fragile reality, isn't it? Keep exploring, keep questioning, and I'll see you in the next explainer.